South Africa's Tobacco Products and Electronic Delivery Systems Control Bill, a piece of legislation from 2022, presents significant constitutional concerns, potentially undermines the rule of law and the separation of powers in South Africa, and gives excessive powers to the Minister of Health, creates a lot of vagueness through very onerous provisions, and very importantly for us at the Free Market Foundation, is an intrusion on individual choice, consumer choice, and personal freedom. We believe in South Africa today, this piece of legislation represents a grave threat to consumer rights, and all South Africans, regardless of whether they are smokers or non-smokers, should be concerned with this bill. And we at the FMF are proud to launch the second in our series of policy papers. And I'm delighted to be joined by one of the co-authors of our second paper, Gary Moore, who is a legal researcher and a senior associate who's been affiliated with the Free Market Foundation for many, many years now, decades in fact. And he is the co-author of Ministerial Power Grab, How South Africa's Tobacco Bill Undermines the Rule of Law. The second author is Martin van Staden. He is our head of policy. He's unable to join us today. He's on an overseas trip, but they very much shared the workload on this very important paper. And I would encourage you, our viewers and listeners, to go and click on the link in the description and in the chat to go and download this report. It's very readable, very kind of concise summary of some of the provisions of this legislation and how it might impact on individual freedoms in South Africa. So Gary, we're going to be relying on you to take us through some of the bulk of the report, some of the main arguments and some of our key concerns, and then also some proposed amendments for how we at the Free Market Foundation think that this legislation could be improved. Obviously, a lot of people have very emotional views on smoking. I'm personally a non-smoker. I don't particularly like tobacco smoke. But this bill also extends to electronic delivery systems, so vaping as well. And I think is something that is using very crude mechanisms, like kind of trying to kill a mosquito with a hammer, I think. But yeah, Gary, you did a lot of the deep research here. So maybe, take us through, just to start us off, what are some of the high level concerns that we have?
All right, very briefly, some background points as well. This report concludes that the bill's provisions are not justifiable in a democratic society, as they disproportionately limit rights and abdicate parliamentary authority to the executive. And this necessitates either significant amendments or rejection of the bill. So this bill is introduced by the Minister of Health to the National Assembly, which may consider, pass, amend, or reject any legislation before it. And the Minister of Health introduced the bill, as you say, in December 2022. Parliament's rules say that bills must, after a first reading, be referred to the Portfolio Committee under which the subject of the bill falls, and the committee must deal with and consider bills referred to it. So the Portfolio Committee on Health is the one dealing with this bill. The committee has invited written submissions on the bill and hosted provincial public hearings, and has generally conducted public hearings from August 2023 till August 2025, with some interruptions. That's 2 solid years. The committee's next formal stage in the process is deliberation by the members, taking into consideration the proposed amendments and comments and proposals received and evidence presented. The committee may recommend approval or rejection of the bill, or present with its report an amended or redrafted bill. The Portfolio Committee on Health issued a media statement in late August this year, stating that on the previous day, the committee that's 29 August, this media statement, that on the previous day, the committee concluded its public hearings on the bill. The committee's statement says that stakeholders who participated in the public hearings include tobacco industry stakeholders, members of the hospitality industry, professional associations, civil society organizations, researchers, academics, private companies, lobby groups, public health entities, statutory bodies, sector experts, political organizations, labor unions, and other interested stakeholders. The committee, according to its statement, received 1,113 oral submissions from the public during the hearings. Of these, 500 were in support of the bill, 495 rejected the bill, and 14 partially supported it. I counted them. There are 4 left out. I presume they were non-committal. The media statement indicates that the next step in the legislative process is that the committee is asking the Department of Health to respond to issues raised by stakeholders and some raised by members of the committee. The committee will then adopt a motion of desirability, which will establish whether the committee is proceeding with the bill at all or stopping and reporting to the National Health accordingly. So the bill is extremely flawed. Where to begin? The bill treats vaping of tobacco devices and nicotine delivery systems on the same basis as it treats conventional smoking of tobacco products, even though vaping is reportedly much less dangerous than conventional smoking, because vaping does not involve combustion or the generation of smoke. The bill also treats vaping of non-nicotine devices on the same basis as it treats vaping of nicotine devices. They should also be treated differently. The courts say that cases which are not the same should be treated differently. The bill also envisages one set of packaging and labeling regulations for, on the one hand, tobacco devices and nicotine delivery systems and nicotine-containing substances and products, and for, on the other hand, non-nicotine delivery systems and substances and products. These should all have different sets of packaging and labeling regulations, if any. The bill's prohibitions against smoking in sundry specified places are unjustifiable intrusions into personal dignity, freedom, and privacy. For example, the bill prohibits smoking while standing under the roof of an otherwise open space, or while standing next to a wall abutting an otherwise open space. The bill prohibits smoking in a workplace, unquote, even if only one person smoking ever works there. The bill prohibits smoking on the outdoor stoop or veranda of a private dwelling. The bill prohibits smoking in any place where a self-employed person works. It prohibits smoking in one's own home or private workshop. The bill also prohibits smoking in cars. It prohibits anyone from smoking in his or her private vehicle if that person uses it during employment or work. The bill prohibits anyone from smoking in a private vehicle even if the owner uses it merely to drive from home to work and back. These are excessive intrusions into personal dignity, freedom, and privacy. The bill prohibits smoking anywhere in South Africa's territorial waters. It prohibits smoking on the open deck of an ocean-going ship registered in any country. The bill unconstitutionally delegates to the minister the power to create offences for vague and unfettered reasons. It empowers the minister to make regulations prohibiting smoking in any outdoor public place or workplace where smoking may, unquote, pose a health hazard. The bill enables the minister to prohibit smoking in any outdoor public place where this smoking may pose a fire hazard. This is unnecessary. This sort of thing is already dealt with in legislation administered by the Ministry of Forestry, Fisheries and the Environment. The bill also authorizes the Minister of Health to prohibit smoking in any outdoor public place where smoking may pose any other hazard. This gives the minister vague and unfettered powers to prohibit outdoor smoking for reasons that are not clearly aimed at a concern about health. The bill empowers the minister to prohibit smoking in such other place where the minister considers it appropriate, unquote, to prohibit smoking in order to reduce or prevent public exposure to smoking. This gives the minister power to prohibit smoking on any specious excuse. The bill gives persons in control of public places unfettered powers to prohibit smoking outdoors. This is wide enough to enable every municipality to prohibit smoking in and on all their public roads, pedestrian footpaths, public squares, parks, and beaches without exception. The bill unconstitutionally prohibits all advertising of all tobacco, nicotine, and non-nicotine smoking products. This blanket prohibition of advertising violates the fundamental right of everyone to freedom of expression, which includes the freedom to impart information. The Constitutional Court has observed that freedom of expression is valuable for many reasons, and that individuals need to be able to hear, form, and express opinions and views freely on a wide range of matters, including contentious matters. In 1995, the Supreme Court of Canada declared that the provisions of that country's Tobacco Control Act prohibiting all advertising of tobacco products were an invalid limitation of the right to freedom of expression in that country's Charter of Rights and Freedoms. The bill unconstitutionally confers on the minister plenary power to legislate product standards and ingredients. The Constitutional Court has ruled that Parliament cannot assign plenary legislative power to a minister. At most, Parliament can delegate only limited regulatory authority. The bill prohibits anyone from selling tobacco and smoking products to any place within a prescribed distance of premises providing educational training to a child. This gives the minister unfettered discretion to prescribe any distance from a school, whether near or far. There should be clear parameters on the exercise of these powers to prevent the minister from prescribing unreasonably long distances. The bill prohibits sales of tobacco and smoking products to any place prescribed by the minister by regulation. This gives the minister unfettered discretion to prescribe any place whatsoever as a place to which sale of the products are prohibited. The bill prohibits the sale of tobacco and smoking products to consumers through postal or courier services or the internet or by any other means as the minister may prescribe by regulation in furtherance of the objects of the Act, unquote. The minister may prescribe additional requirements applicable to the sale of tobacco and smoking products to further the objects of the Act. These provisions are vague and do not properly define the scope of the minister's power to prescribe regulations. In the same vein, the minister may require a manufacturer or importer of tobacco and smoking products to submit any information to further the objectives of this Act, unquote. The bill, read with certain statutes regulating maximum fines for criminal offences, provides for the imposing of unduly severe criminal penalties for the offences created in the bill. For example, a person who is in control of a place where smoking is prohibited and who fails to ensure that nobody smokes in the no smoking area there commits an offence and is liable on conviction to a fine of up to 200,000 rand or imprisonment for up to 5 years or both. Anyone who sells tobacco or smoking products to any places prescribed by the minister by regulation commits an offence and is liable on conviction to a fine of up to 600,000 rand or imprisonment for up to 15 years or both. These maximum penalties are disproportionately harsh. The Bill of Rights declares that everyone has the right not to be treated or punished in a cruel or degrading way. The authorized penalties in the bill are generally excessive. The bill provides for 6 categories of punishment of increasing severity: a fine of up to 10,000 rand or imprisonment for up to 3 months or both, a fine of up to 20,000 rand or imprisonment for up to 6 months or both, a fine of up to 200,000 rand or imprisonment for up to 5 years or both, a fine of up to 400,000 rand or imprisonment for up to 10 years or both, a fine of up to 600,000 rand or imprisonment for up to 15 years or both, and a fine of up to 800,000 rand or imprisonment for up to 20 years or both. These punishments are unduly stringent. Imprisonment for 15 years is the punishment for murder, and imprisonment for 20 years is the punishment for a second offense of murder. The bill states that the National Health Act's entry, search, and seizure provisions will apply. They empower officials to enter premises, including private dwellings, to inspect everything, and to seize material that may provide evidence of an offense. Those entry, search, and seizure provisions of the National Health Act give officials draconian powers. An occupant or other person present on the premises being searched must furnish information about the matter under investigation on request by the officials conducting the search. The officials may overcome resistance to this entry and search by using such force as is reasonably required, including the breaking of a door or window of the premises, and they may exercise these powers without a warrant if there are reasonable grounds to believe that a warrant would be issued and that the delay in obtaining it would defeat the object. Absurdly, the National Health Act insists that any entry and search of premises in terms of the Act must be conducted with strict regard, unquote, to decency and good order, including the rights of affected persons to dignity, freedom and security, and privacy. I don't see how knocking down a door or window will promote the individual's right to privacy, but there you are. The document also includes now contention that the bill unconstitutionally prohibits policy participation by the tobacco industry, but that assertion is not expanded on in the document, so I'm not clear which provision of the bill they have in mind or what is meant by policy participation. I think that's all I have to say, David, at this stage.
Great. Thank you, Gary. Yeah, I think that this really is a good example of government overreach. And I mean, the phrase that keeps coming up is vague and unfettered powers. And I think that really sums up the essence of this legislation. So Gary, we've got a couple of kind of comments coming through in the chat. Maybe I'll just show some of them on the screen and you can give your thoughts there. So Leanne says, government lacks the capacity and competence to handle violent crime. How can it realistically police lifestyle regulations like private smoking or vaping? I mean, I think just some of those, go ahead.
Well, it won't, for the same reasons that it doesn't have the capacity and competence to handle violent crime. It won't. One of the commentators in writing a week or so ago made the fair point that these offences, these criminal penalties, are high with the hope of having a psychological deterrent effect, but because the government doesn't have the capacity and competence to enforce laws, legislation.
Okay, and then Josie Mojo says there are strict regs regarding searches without cause, yet this bill seems to disregard this. There must be a constitutional challenge on this element alone. Do you have any thoughts there, Gary?
Yeah, everything I identified are unconstitutional measures, and that will probably be attacked if the bill comes into law in its present form. And I doubt that it will. I think the bill will either be withdrawn or be subject to extensive amendment by this committee.
And what is the status at the moment, Gary, with the committee?
The status, the last I had, was the committee's media statement on 29th August saying that it will call on the Department of Health to respond to all issues raised by the many stakeholders and by committee members. And thereafter, the committee will adopt a motion of desirability, which will establish whether the committee is proceeding with the bill or stopping with the bill, which I presume to mean rejecting the bill. But I haven't heard anything since their media statement of 29 August.
Okay.
So that's a month and a half ago, right?
Yes, yeah.
Nearly 2 months ago.
All right, yeah. I think maybe we could unpack some of the rule of law implications of this legislation, Gary. I think, particularly we're looking at some of the very onerous criminal implications there. And I think, jail time and so on, for lifestyle related vices, and I think our colleague Zakele Mtembu often refers to this concept that vices are not harms necessarily. Eating too much fatty food or sugar or going horse riding or cycling, these are potentially very risky lifestyle choices. But that is an individual preference. It's something that you as an individual take on board, knowing the various risks, and you balance the risks with the benefits. So maybe you could speak to some of those kind of legal problems as well, that the ministry is basically developing criminal sanctions here, which is, my understanding is that that's the domain of the legislature itself. So there's a kind of an ultra vires concern here that the minister is exercising powers that he doesn't have.
Well, I think a lot of it is that the bill itself confers power on the minister to create prohibitions himself or herself, and failure to comply with the minister's prohibitions are an offence under the bill. So it's not so much that the minister is exceeding his or her powers, but that the bill unconstitutionally gives power to a minister to create offences. I should also add that these penalties of periods of years, the very high periods of years, are probably bumped up by the legislature because they're meant to trying to get people to pay a hefty fine instead. And fines are determined by the Minister of Justice under the Magistrates Court Act. That's where all fines ultimately have their source. And to calculate how they apply to your statute, you have to do a pro rata adjustment. Now, the Minister of Justice hasn't increased fines since 2014. So all other government departments, if they're trying to impose a hefty fine, really have to jack up the alternative period of imprisonment. That's what's behind this. I think government departments and ministers will introduce statute bills with milder criminal penalties if the Minister of Justice would increase the maximum fine payable under the Magistrates Court Act by a district court. That's where the ultimate source of these things is determined. And that's probably a good thing to have it all done in one place by the Minister of Justice under the Magistrates Court Act, because before that was introduced in the 90s, every statute provided its own criminal penalties, fines, and periods of imprisonment. But with galloping inflation, the fines became, in real terms, less of a deterrent. And every government department was introducing bills in Parliament that had nothing else to do but try and increase the criminal fines payable in the bill, in their respective bills. And that was clogging up the business of Parliament. So they got this new arrangement where only the Minister of Justice does it once under the Magistrates Court Act, and every other statute refers to that implicitly.
I think some of the more onerous aspects of this legislation apply to what you may or may not do in terms of smoking in the workplace. So, I think rather foolishly, the bill prohibits smoking in a workplace, even if you're the only person who works there. So,
Correct.
I mean, Gary, if you're working from home and you're having a cigarette in your office there, you will be in violation of these laws. If you are driving to work on your own in a vehicle that is yours, you may not smoke in your own vehicle. And
The
so,
way it's written, yes.
yeah. And so I mean that just seems unduly excessive intrusion into personal privacy, don't you think?
Definitely. That's the reasons I identified those particular provisions of the bill, because these are all objectionable provisions of the bill that, in my view, would be subject to constitutional attack and which should be removed from the bill. There's three possible options open to this committee. They can reject this bill outright. They can make all the necessary amendments, and we have framed a formal schedule of amendments, necessary amendments to this bill, and an explanation of that. And the third possible thing that the committee can do is reject this bill and write its own. What the big document doesn't say is that you do need the Assembly's consent. A committee does need the Assembly's approval before a parliamentary committee goes ahead and writes its own bill. I very much doubt if the committee will sit itself down and write its own bill on such a contentious subject.
Yeah, but I think that point reveals an interesting tension between the legislature and the executive, that really, in many respects, the legislature has abdicated much of its responsibility for lawmaking. And what you have in lieu of that is rule by executive decree. And so you have a rather energetic, paternalistic Minister of Health in the form of Aaron Motsoaledi,
yes,
who wants to determine what people's individual lifestyle choices should be. And I think that's very important to resist that. And, that's why when we talk about the rule of law, that rules are not the rules by man, they are rules of law, and that they apply to everyone, and it's not just at the discretion of the minister. I think a good example of this is the restrictions on smoking near a school or a place of education. And the minister has very, very wide discretion to determine the geographic footprint. Yeah, so you could say the entire country is within proximity of a school.
In theory, yes.
You may not smoke at all, ever.
This note here at the bottom by Inov Rupley makes another good point, is that there's just too much legislation generally. Common law is being replaced by legislative rules. Under common law, there's the law of nuisance, which also has a role to play, or would have if it was left free and unfettered.
No, absolutely. And I think there's also a freedom of commerce aspect to this, which Ilza Skernrad mentions in the chat. What if the tobacco industry, retailers, FMF, and smokers launch a class action for smokers' rights? Yes, I agree, Ilza. I don't know if we have the capacity to launch a class action, but smokers' rights are just as important as everybody else's. Yeah. And if you want to open a smokers' pub, I mean, if you think of smoking clubs, for example, like cigar clubs, that's something that could be infringed upon. And I
never thought of smokers' pubs and cigar clubs when I wrote this, but now that those are mentioned, I just think on the face of it, the bill prohibits all those forms of advertising and promotion.
Yeah, no, absolutely. I think exactly. That's the free expression infringements as well on, in terms of plain packaging rules and where you may or may not advertise. Many years ago at the Free Market Foundation, before my time, there was a campaign where some of the staff put stickers on their motor vehicles with dead bodies on the in the imagery, and that was designed to say, well, look, this is akin to putting images of the health effects of smoking on your box of cigarettes, and if you consider how many people die in motor vehicle accidents every year in South Africa, it's in the thousands, and yet we all enjoy the benefits of driving our own vehicles, and we make that risk calculation ourselves. Yes, driving is very dangerous and hazardous, but it's also very convenient. So we should treat other lifestyle choices in the same way, whether it's smoking or drinking alcohol or eating sugar.
Yes. I have seen among written comments that the bill prohibits policy participation by the tobacco industry, but I can't trace if that is supported in the bill at all, because the bill itself prohibits advertising and promotion of a marketing nature, but doesn't go so far as to prohibit lobbying or policy participation, unless
I think there's a very, very interesting point to be made on lobbying. And Martin van Staden, who authored this paper together with you, wrote an interesting piece in the Daily Friend saying that the tobacco industry has a right to lobby to protect its interests. And
yes,
I think that that's very important. And we should also remember that there's a very sophisticated public health lobby from global institutions and other networks that is very openly lobbying against the tobacco industry.
yeah. I can't see anything in the bill that will prevent the tobacco industry from presenting counter arguments to the government or from participating in policy negotiations.
Yes.
Advertising, yes, that's flatly prohibited.
Okay.
Look, this country where I live now, here in Sydney, New South Wales, they have all this stringent stuff without exception. That's all in force here. If you want tobacco or cigarettes, you have to go out and find it.
Yeah. And I'm sure it doesn't stop people from engaging in smoking.
Well, yes, those who smoke, will make sure they can get their cigarettes. But so I was telling you before we went online about the price of cigars here?
Yes.
All right, I'll just repeat it here. That individual Robusta size Nicaraguan cigar will cost you $50 Australian, which is about 520 plus 530 rand. So it's a very pricey, what can I say, pleasure to pursue. And as you rightly say, much of it will be the excise duty.
I think this legislation, the tobacco bill, reminds me of many of the health policy measures that were taken during COVID in South Africa. Australia also had some pretty heavy-handed laws that were passed. Yeah. And, I think one of the consequences, particularly of the tobacco ban during that period, was that you saw a rapid growth in the illicit market in South Africa. So
yes,
and there's been a long tail of that and a long effect of that, a lag effect, where a lot of consumers have now gone to far cheaper, unregulated products.
Yeah.
And if what you care about is health regulations and transparency in terms of health impacts, these under-the-counter kind of options are not really abiding by that. So, what that means is the very high administered prices, the kind of the minimum tariffs and taxes taken collectively amount to about 25 Rand per pack of cigarettes for the formal cigarettes.
25 Rand per packet of 20.
Yeah, so and
that's not a lot.
Yeah, but
that's only
think,
1 Rand a cigarette.
No, that's just in terms of the taxation. So if the box of cigarettes costs you between 25 Rand and 65 Rand, then 25 Rand of that is being taken in terms of taxes and other administered levies. So that is driving.
Okay, I didn't inquire after local cigarette prices from this local tobacconist of mine, other than these Cohiba size cigars, but I'm sure they're a lot more pricey equivalently than that Rand price you mentioned.
Yeah, so I mean, the illicit cigarettes cost you between 5 Rand and 25 Rand total.
Ilse Schoenraad makes a point here that her friend recently visited Melbourne and bought illegal cigarettes at a small shop at a quarter of the price.
Yeah, so that means that the demand is still there in spite of the regulations, and the people are going to go out of their way to seek out those products.
Yeah, this bill. Sorry,
go ahead.
No, this South African bill is really aimed at deterring promotion of smoking, and makes smoking inconvenient, and it also makes purchasing inconvenient.
Yeah. All right. So, well, Gary, I just wanted to say thank you very much for sharing your insights with us today, and also for your hard work on this report. I would really encourage our viewers to go down and check out the link in the description and go and look at that report, study some of the recommendations. We're going to be doing a lot more publicity around this. And I think, as I mentioned in my introduction, even if you are a non-smoker, you should care about this, because first they come for the smokers,
correct,
then they come for the drinkers, then they come for the people with sweet tooths. And, really, this is a question of liberty, which is really our animating principle here at the Free Market Foundation, which is why we care very much about some of these instances of state overreach. And I think in a country, and many people in the chat have been talking about the role of the police. This last few months, we've been seeing the testimony of the Madlanga Commission of Inquiry. There's a parallel process happening in an ad hoc committee in Parliament. And really, there are very serious governance questions around the police, a lot of allegations of criminal capture. Yeah. And we have runaway violent crime in this country, which really impacts the lives and the livelihoods of individuals. And here we have a government whose main preoccupation seems to be being a busybody and nannying our personal lifestyle choices. And I think
it will also be an opportunity. Yes, sorry.
No, go ahead.
It will also be an opportunity for corrupt police to exact bribes from cigarette retailers who are perhaps not complying strictly with the legislation.
And individuals like you and I as well. But Gary, thank you very much. I think this is important work, and I encourage our viewers to go and engage with this research, and also to spread the word about some of the dangers inherent in this legislation. Thank you very much. That's it from me, David Ansar, and the FMF team. Remember, stay free.
Keep well, everyone.